And we're really pleased to have an expert speaker this morning, Tom Jacobs, partner at Jackson McDonald, to present on this subject. Tom has over 20 years experience advising clients in the building, construction and engineering industries and has assisted many clients working on the delivery of infrastructure projects and working very hard at the moment on lots of infrastructure projects. He was recently recognised in the 2022 Best Lawyers Australia rankings for construction, infrastructure law and for alternative dispute resolution. And it's a pleasure to introduce Tom Jacobs.
Thanks very much, Andy. Thanks very much, everybody, for joining us today. Welcome. So I'm going to talk about the Building and Construction Industry Bill. Before I do that, it wouldn't be a presentation by a lawyer if I didn't put up a little disclaimer. So we'll move quickly on from that, however. And on the slides, you can see is my outline of the presentation today. I'm going to talk for the next sort of 45 minutes or so. And the things I want to cover in this session are just a reminder of the principles of the current security of payment legislation that we have. And then I'm going to talk a bit about the new bill, the Building and Construction Industry Security of Payment Bill. And in particular, I'm going to talk about when do we think it might come into effect, what are the sorts of things that bill is going to change from the way we experience things these days under the Construction Contracts Act. I'm going to talk about some of those changes in particular, changes to pay when paid provisions, some of the changes that they're proposing to make to notice-based time bars, some of the changes that are proposed for retention money trusts, a particularly relevant issue given the circumstances surrounding Pindan over the last few days. There are a lot of very dissatisfied, unhappy, angry subcontractors who will have potentially lost retention monies. We're also going to talk very quickly about offences, and there are a number of offences introduced under the new legislation. And then I'm going to spend a little bit of time talking about the new way in which adjudication will be conducted under the new bill. Andy's mentioned that if any of you have any questions, please use the Q&A function. I'll attempt to deal with those at the end of the webinar, but of course, very happy to take questions thereafter, either on email or telephone. All right. So hopefully all of you are already familiar with the current version of the Construction Contracts Act. It does effectively three main things. It prohibits certain terms in construction contracts. It introduces implied terms into construction contracts if your contract doesn't have a provision about certain things. And it introduces the rapid dispute resolution process that we all know and love, adjudication. Okay, so what are the sorts of things it prohibits? It prohibits pay when paid, basically a provision that prohibits a main contractor or anyone else in the chain from saying to someone beneath them, I'm only going to pay you when I've been paid. So that sort of provision is an example of what's prohibited under the current legislation. It creates implied terms around things like how and when a party can get paid. And those terms are implied into construction contracts if the contract doesn't have a written provision about those sorts of things. Now, of course, most contracts, bespoke contracts or AS forms of contract do have written provisions about those things. But things like purchase orders or oral contracts, they don't. And so that's where the Act has been quite useful in bringing a bit of regulation and clarity to some of those important mechanisms for getting paid. And as I've said, it introduces this rapid dispute resolution process called adjudication. And so under the current WA legislation, the adjudication process involves these sorts of steps. It's based on legislation that was introduced in the UK, probably about 25 years ago now. But it's different to the adjudication process that has been adopted in pretty much every other state of Australia, apart from the Northern Territory. The difference between the states is one of the reasons that has driven the government to change the WA legislation. And so what does the current process involve? Well, it involves the submission of a payment claim. That payment claim can be either by a contractor or by a principal. It involves then the crystallisation of a payment dispute. That payment dispute arises on the earlier of the date for payment of the full amount of the payment claim, i.e. when no payment or partial payment is made, or when the claim is rejected or disputed. A payment dispute can also arise when security or retention is not released. So from that payment dispute date, a party has 90 business days to decide if they want to go to adjudication. So that's about 3 or 4 months. To start adjudication, a party prepares an adjudication application. You can do that very quickly using the Jackson McDonald Get Paid Quick adjudication app. The party lodges that adjudication application with an adjudicator and serves it on the other side. A response to an adjudication application has to be made within 10 business days, so very quick, only 2 weeks. The response can set out all of the reasons why a party is not paying. Those reasons can include any possible reasons that the respondent might dream up. The adjudicator then has 10 business days to determine the dispute. Again, 2 weeks. That period can be extended if everyone agrees to it. But it's usually my experience that the adjudicator makes that decision in 10 business days. If an amount is payable, the adjudicator will say when it has to be paid. The amount payable is only paid to the applicant, the party who seeks payment. Unlike litigation, you can't run counterclaims and have money flowing in the other direction. So the adjudicator usually determines the matter on the basis of the submissions alone, but they can call for further submissions or hold a conference. Those sorts of things are not common, but they can occur. And an adjudicator can dismiss an application and make no decision about the merits if they think it hasn't been prepared properly or served properly, or if the matter's a bit too complex. In my experience, I think there's only been 1 or 2 that have been rejected because of complexity, so that's pretty unusual. So the Act, when it was originally introduced, it prohibited the recycling of claims. That was changed in 2006 or 7 when there was some amendments. And a determination has to be paid by the time stipulated. If it's not paid, then work can be suspended and the applicant can go and enforce the determination, convert it into a court judgment, and then bring to bear the powers of enforcement like property seize and sale orders or statutory demands and winding up petitions to get that judgment paid. In terms of the costs, people generally bear their own costs. They have to pay the adjudicator's fees. Those are usually split 50-50 between the parties. The adjudication process doesn't have any effect on other proceedings. So they can be commenced after, or they might be going on at the same time. And the beauty of this adjudication process is that it's binding. And there are very, very limited rights of appeal. Essentially, a dissatisfied party can only argue that the adjudicator has done something unfair or done something that they shouldn't have done. They can't appeal and ask a judge to have a look at the merits or the facts of the dispute again. So the process follows a reasonably straightforward procedure. My slides appear to have frozen. No, they haven't. There we go. And we can see we move through the payment claim, payment dispute, make our application, get our adjudicator appointed, make the response. The adjudicator then has 10 business days to either dismiss it or to make a decision. And then after all of that, the parties can enforce it, look to go off to court for final relief, or try and have it set aside. So that's the current universe that we live in. But the current universe is going to change. It's going to change very soon. And it's going to change quite significantly. So I think the Minister for Commerce announced that the Security of Payment Bill is going to be reintroduced to Parliament next week. So the current bill had reached the process where it had been introduced, read by both the lower and upper houses of Parliament, and it then stalled in about November last year, and Parliament was then had a summer vacation, as it does, and then it was prorogued while we all got ready for a terribly exciting election. Post that election, government needs to reintroduce the legislation. It needs to be read by both houses of Parliament and then receive royal assent before it comes into force and effect. The word on the street before the events of this week was that this act is probably going to come into some sort of force or receive royal assent around August or September this year, but might not come into force until January. The reasons for that at the time were that there were some regulations that need to be prepared, and various employees need to be engaged by the Building Commission in order to deal with the various offences in the legislation. I think that the events of this week have made it very, very clear to government and broader industry of the enormous protections that can be brought to bear by the government introducing this piece of legislation. It does change the landscape quite significantly, with the objective of improving the flow of cash and the protection of cash flow. And that protection is really for the benefit of everyone involved in the contract chain, and therefore for the benefit of industry as a whole. You may not be aware of this, but the construction industry is a gold medal winner. It's a gold medal winner because it is the industry that has the greatest number of insolvency events out of any industry in Australia. It's not the sort of gold medal the industry is terribly proud of, but unfortunately the nature of the industry and the work and some of the practices means that it's a pretty tough place to operate. My sympathies go out to anyone and everyone that's been affected by the events of this week, or indeed of some of the large insolvency events we've had over the last couple of years. Anyway, on to the new world, the new paradigm. So what's not going to change? Well, the essential principle of pay now, argue later. This quick interim decision on an entitlement to payment, that's not changing. A quick and inexpensive dispute resolution procedure, that's not changing. But what is changing is a lot of other stuff, okay? The Act is creating a brand new entitlement to payment. And hopefully there will be an incentive, greater incentive for people in industry to use the legislation. And as I've said, these changes are possibly going to happen a little quicker than perhaps all of us legal people thought. So the slide I'm demonstrating or showing to you now shows what the Act is intended to do. So I'm quoting there directly from the Act. It's to provide an effective and fair process for securing payments under construction contracts, a bit like the objective of the current legislation, but it's also for related purposes. So it applies to construction contracts, but only those construction contracts entered into after the Act comes into effect. Okay, it'll apply to construction contracts if they're written, or if they're oral, or partly written or partly oral. It may well apply to contracts entered into in this state or elsewhere. and it'll apply to contracts governed by the laws of WA or possibly by the laws of other jurisdictions. The trigger will be, does it apply to work being done in WA? And Section 6 of the Act talks about construction contracts being contracts for construction work. The definition is fairly similar to the current definition. But one important distinction to be made is the mining exclusion. The mining exclusion under the current Act was fairly broad, and that mining exclusion is going to be narrowed. The mining exclusion basically says that the Construction Contracts Act doesn't apply to things like drilling for oil, constructing plants and shafts and quarries that are used for the extraction of oil, gas, and other sorts of minerals. Now, the current Act is going to narrow that definition, and although it's not going to apply to the drilling and extraction, it is going to apply to the construction of process plants and the installation of plant and machinery that's used for the processing of those sorts of things. So that's good news for those of us that are involved in the installation of those bits and bobs of kit, because it means that this contract and this legislation is potentially more available to us than it might have been. Some of you might do a bit of work in the residential sector, clearing land and so forth, and doing earthworks and civil works for developments, residential developments. So the legislation has some exemptions for home building work, but the exemptions really are focused upon that work that is in the residential building sector. So if I, Tom, enter into a building contract with Billy Bob Building Co. to build my house, apologies for the appalling alliteration there, and that contract is for less than $500,000, then that sort of contract is not caught by this legislation, okay? The reason for that is that I have rights to go off to the Building Commission and make my complaints about the quality of the work, and the builder can go off to that Building Commission and that forum to get paid. So there's no need for adjudication or the other bits and bobs under this legislation to apply in that sort of forum. So the flip side to that is, if you are a subcontractor on these sorts of projects, this legislation does apply to you. If you are a body corporate, so not an individual, and you are procuring the construction of dwellings or multiple dwellings, then this legislation will apply to you. And if the value of the contract is over $500,000, the legislation is going to apply. So something to be aware of, these exemptions for home building works are new. It also changes some of the provisions that appear in the existing legislation, and it introduces some really interesting new changes. So I mentioned very briefly the pay when paid provisions. That clause that says you only get paid once I'm paid. So that provision was attempted to be circumnavigated by people inserting provisions into their contract to say things like, well, I'm only going to give you an extension of time if I get an extension of time from the principal, or I'm only going to give you a variation if I get a variation from the principal. And so what this legislation does is it says those sorts of provisions are deemed to be pay when paid, and you're not allowed to have and rely upon those sorts of provisions either. So it's expanded that definition, and that's really useful if you happen to be a subcontractor, someone a little bit lower down in the contracting chain. So those provisions are a little bit more broadly defined. As with the current legislation, you can't contract out. So that's what no contracting out means. So you can't try and be clever and say, I'm going to write a provision in my contract that says, I don't want that pesky security of payment legislation to apply to me. That doesn't work. Those sorts of provisions are void. The other really interesting thing that this Act is going to introduce, well, I say interesting for us lawyers because we get excited about this sort of stuff, is that notice-based time bars have no effect. So what's a notice-based time bar? I'm sure you're pretty familiar with that sort of drafting that says, if you want an extension of time, you've got to put in a notice. And you've got to do that within 2 or 3 days of something happening that you think might delay your work. That's a notice that is based on time. And what those provisions often go on to say is something like, and you don't have a claim, or your entitlement to make a claim is lost if you don't put that notice in. So what this drafting is intended to do is to try and alter some of the risk that is otherwise created by those provisions. We don't really have an idea about how the Act is going to be interpreted, but I think it's worth just going and having a quick look at section 16, which is where one finds this provision. And the Act says that notice-based time bar provisions are going to possibly be declared to be unfair. And if that's the case, then they'll have no effect, which means a principal will not be able to say, I don't have to pay your delay damages, or I don't have to pay your variation claim because you didn't put your notice in on time. And now that's a paradigm shift, massive paradigm shift for the WA legal position. There was a big decision of the West Australian Supreme Court a few years ago, CMA Assets and John Holland, 2016, I think, Supreme Court of Western Australia, where Justice Allinson made the observations that notice-based time bars, although their effect may be harsh, they nevertheless represent the bargain that the people have signed up to. And the outcome of that decision was that CMA Assets had to pay liquidated damages to John Holland, even though John Holland had delayed the progress of their work. And the reason they had to pay that liquidated damages sum, you know, a not inconsiderable sum of $7 or $8 million, was because CMA Assets had put their notice in 3 days late. Okay? Even though John Holland clearly delayed them. And so that situation is what this piece of drafting is intended to overcome. The Act gives us a little bit of guidance on when someone might decide that it's unfair, and it could be an adjudicator, an arbitrator, or a court. So this has widespread application. And it says things like, in determining whether one of these time bars is ineffective, the adjudicator will take into account when the party who is required to give the notice could have become aware of the relevant event, when and how the notice had to be given. So some time bar clauses say you've only got 24 hours to give the notice. The adjudicator or judge needs to take into account the presumption that parties have read the terms of the contract and agreed to be bound by the terms of what they sign. But they're going to have a look at whether compliance with the provision is unreasonably onerous. So, for example, if you need to give that notice in 24 hours, and in that notice you need to give a raft of information, detailed information. And then they're also going to take into account whether the matters in that notice or the time bar provision itself is final and binding. Going to be very interesting to see how that is going to be considered. What else is the Act doing? Something that's of relevance for subcontractors in particular, where contractors and principals take retention monies. The obligation is going to be for the creation of a separate bank account and for the deposit into that bank account of retention monies. And the idea behind this, and I think it's a very good idea, it is in the circumstances that have unfolded this week, where a major contractor has gone into insolvency. Any retention monies that subcontractors might have had retained, if those retention monies have been stored in Pindan's bank account, then they have been mixed with Pindan monies, and it is impossible for the subcontractor to get those monies back. This arrangement ensures that in future, or will ensure in future, that those retention monies are put into a separate bank account, that is a trust account, and that the liquidator is not able to say that those monies are the contractor's monies if the contractor goes insolvent. So that keeps those monies protected, and at least that is something that can go back to the subcontractors all the way down the contracting chain in the event of an insolvency. There's going to be some issues to bear in mind in terms of how you create and then manage those accounts, because it's not straightforward. I don't believe that those provisions are going to come into effect on day one of the introduction of the Act, but it's something very much to keep an eye on, because if you are a subcontractor and yet you subcontract work, you will have an obligation to keep, if you are retaining funds from your subcontractors, you will have an obligation to put those monies into a separate trust account. And if you don't, you may well be committing an offence, which is a neat segue into just a very high level look at some of the offences that are going to be created under this new legislation, a raft of offences. So here is an example of one of the sorts of offences. Certain information needs to be provided, and there are penalties. I'm not going to discuss these in detail, but just to give you an idea that this new legislation has got a lot of stick to it, okay? Section 65 is a really interesting provision that's going to make it an offence to threaten or intimidate claimants who are entitled to make a progress claim. Penalty, $50,000. That might well be the other way round. $50,000 for a corporation, $250 for an individual. I should say all errors in the slides are mine. There has been an undercurrent, a rumour, that people don't invoke their rights and entitlements under the current legislation because they're afraid to do so. They think that if I take adjudication steps, then I'll be blacklisted. I'll never be able to get work for that contractor or that principal ever again. And I've heard that. I've had clients say to me, Tom, we'd love to adjudicate. Well, not love. No one likes having to take that step. But they would take that step if they didn't feel that it would have adverse consequences on their future business. Indeed, there was an article in, I think, the West Australian about a plastering subcontractor to Pindan who had been promised payment to the point where he was owed over $200,000. And he didn't avail himself of the rights he had under the Construction Contracts Act to adjudicate and get that money back. He was hoping that promises to pay and future work, and perhaps nervous about being blacklisted. And so he kept on working and didn't do anything about it. So something like this sort of provision is, I think, going to be helpful in terms of encouraging principals and contractors to take a more pragmatic view of the adjudication process. In my opinion, an adjudication it's akin to a second review by a second superintendent of a party's entitlement to payment, and it really needs to be considered as such. it's not the same as starting litigation, which is a public process and very damaging to the relationship, but usually only occurs at the end of the project. Adjudication happens usually whilst the project is underway. We can also see there section 87. Again, I think, apologies, those penalties are the other way round. It's the individual that's going to have a $250 penalty, but the corporation penalties are significant, and those directors of those corporations can be potentially personally liable if they've not taken steps to ensure that retention monies are held in the proper location. So very much carrot and stick. So finally, in the next sort of 20 minutes or so, I just want to talk about the new adjudication process. So it's the same, but it's different. I'm going to run through this new statutory entitlement, touch on whether or not your contract is still relevant, and talk about the adjudication process. So this just visually describes how we move through the process. This legislation creates statutory entitlement to be paid progressively. A party makes a payment claim. There is a response to the payment claim. Stage 2 is the adjudication process itself, which, like the current process, it involves an application, a response, and a determination. Stage 3 has a few changes to it as well, both in terms of the review and in terms of enforcement. So looking at those 3 stages in turn, the statutory right to payment. So section 17 of the Act creates a separate and additional right to payment. What does that mean? Well, your contract usually is the totality, you think, that governs your relationship with your other party. It sets out your scope of work, what you got to do and when you get it by, and it sets out what you're entitled to be paid and how you go about getting paid. When you put your payment claims in, what the assessor, superintendent or principal or other contractor has to do when they get your payment claim, whether you need to put in an invoice and when you get paid. All of that's set out in your contract. What this legislation does is it creates a new right to payment. And it says, regardless of what your contract says, you have another way of getting paid, another way of enforcing payment using the Act. The contract might provide the times for how you make a payment claim, but this legislation introduces a new regime, an additional regime. So if your contract says you can make a payment claim every 2 months, this Act says you can make a payment claim every month. So that means even though your contract might say X, the statute is giving you another and possibly better and quicker right to payment. So really important to be aware of it. It creates an ability to make statutory payment claims after the DLP ends, and you can make your payment claim 6 months after you've completed the work to which the claim relates. Section 24 of the Act sets out what your statutory payment claim has to look like. And this is really important. Regardless of what your contract says, your statutory payment claim has to be in writing. It has to be in the approved form. Now, we don't know what the approved form is yet, but we just need to be aware that there might be an approved form that is attached to the regulations. But we don't know what that is yet. It must indicate the amount of the payment claim. It must describe the items and quantities of work to which the claim relates. Excuse me. So it can't just be claim for $10. It's got to describe the work. Most importantly, it has to state that it's made under the Building and Construction Industry Security of Payment Act. So it needs to have that written on the bottom of it. And there are some additional requirements that will apply in relation to payment claims for home building work. So that's what you've got to do to make your statutory payment claim. And so when do you have to pay statutory payment claims? Well, I think the current requirement, the legislative requirement, is that payments have to be made in 42 days after the date of the claim. That's what the current legislation says. You remember there were those discussions about major principals trying to introduce 60 or 90-day payment terms. Pretty unreasonable. It was pointed out to them that the legislation says for construction work it can only be 42. Well, that time limit is going to get shorter. It's only going to be 20 business days for principals and 25 business days for subcontractors and those further down the chain. So it's a bit quicker, which is great. The quicker we get paid, the quicker we can then pay those that we owe money to. We all know that cash is the lifeblood of the industry. But it's really important that if you receive a statutory payment claim, you've got to respond to it. Section 25 of the Act says you've got to give a payment schedule. And there are some requirements that you've got to follow for a payment schedule. It's got to be in writing, identify the payment claim to which it relates, indicate the amount of the payment, and it's got to set out reasons for non-payment. It's got to be given within the time required by the construction contract, or if there is no time limit, 15 business days after the payment claim is made. So your contract might say the certificate from the super comes in 14 days. So that's going to be the time limit for this payment schedule to respond to a statutory payment claim. So the new world means that we need to keep one eye on what our contract says and one eye on what the Act says. We need to be alert to obligations and the timing of those sorts of things in both worlds. It's really important to give reasons if the scheduled amount is less than the claimed amount. You can't say, I'm going to tell you later why I'm not paying you. That's not going to be good enough. If you want to offset liquidated damages, you've got to do it in the schedule. The reason for this, I think we might have just lost our screen. Just double checking that.
It's still there, Tom.
It's still there, good. I've just lost the ability to see it. So we'll see if we can get that back up at this end. So, but that's fine. Payment schedule has to provide reasons. Sorry about that, thank you. In particular, oh, here we go. If you don't give a payment schedule and the other party takes you to adjudication, you effectively won't be able to fight that adjudication. You won't be able to make a response to the adjudication application. You won't be able to say in your response, oh, the reason I didn't pay that was because the work was defective or the work was late. You can only fight an adjudication based on reasons that you've put in your payment schedule. absolutely vitally important that you give a payment schedule and that it has all of the reasons that you think are relevant for not paying. All of the reasons, even alternative. For example, if it's not that, then this. Put it all in. If you don't put in a payment schedule, then you've given the applicant some really powerful things that they can do. They can go and commence debt recovery proceedings. They can commence an adjudication application, which you can't fight. In debt recovery proceedings, you can't fight the debt recovery by saying that the money's not due because it's defective or it's late or you've got liquidated damages that you want to set off. They've effectively got deemed entitlement to that amount claimed. So it's bringing back this notion of deemed entitlement. We had a little bit of that in the current legislation for a few years in circumstances where a party was able to rely upon the implied provisions of the Act, because those implied provisions suggested that if a payment schedule wasn't given within time, then a party had to pay the amount claimed. But there was some legislation, there was a decision that came out probably about 2018, I think, excuse me, where the judge decided that the interpretation of those implied provisions had gone a bit too far, and there was in fact no deemed entitlement that arose. So these provisions, or the intent of the current legislation, is to bring back deemed entitlement. So very, very important. Big takeaway. If you get a statutory payment claim, you must put in a payment schedule, you must do it in time, and you must have all of your reasons for why you don't think payment is due. So here we have our new timeline for the adjudication process. We make our statutory payment claim 15 days from the claim or earlier, if that's what the contract says. In goes the payment schedule. Under the current world, an applicant has 90 business days to take their dispute off to adjudication. Here, the new world, that time limit is much, much shorter. You only have 20 business days. The entitlement crystallises when you get that payment schedule, or the absence of a payment schedule, the date that it was due to be given. That crystallises your entitlement to go off to adjudication, but you've got to exercise that right within 20 business days. If you don't exercise it, you've lost the right to adjudicate on that payment claim. If you don't get a payment schedule as an applicant, you actually need to give the other side an opportunity to give you a payment schedule. So you've got to give them an early warning notice. I think the relevant question there is, if you don't get a payment schedule, as we just saw on that previous slide, you've got deemed entitlement, you might as well just go straight off to court and look for summary judgment on your debt. Why give the other side another opportunity to give you a payment schedule and delay the process of starting adjudication? So the adjudication application is prepared. It's given to the adjudicator, who is appointed by a nominator. The response comes 10 business days after the receipt of the application, and the adjudicator makes their decision 10 days after the response. So your adjudication application has got a few requirements. Section 30 of the Act says your application has to be in writing, and it has to be in the approved form. It must identify the payment claim. It must identify the payment schedule, must be accompanied by a nominating fee, and it may contain submissions. it must be given to the respondent 1 business day after it's made. So you don't have to serve it on the respondent and the adjudicator nominating body on the same day, but you've got to give it to the respondent very, very quickly thereafter. Then along comes the response. As I've said, again, the response can only refer to and articulate reasons that were set out in the payment schedule. You can't put in new reasons. But by a similar token, your adjudication application can't ask for things that weren't in the payment claim, and you can't run your claim in an adjudication on a different basis to that which was articulated in the payment claim. So if you said your entitlement is because you've got an entitlement pursuant to a particular provision of the contract, you can't come along in your adjudication application and say that entitlement is because of some other provision under the contract. And importantly, adjudications are only available for things that you're due to be paid under the contract. Consistent with the current world, you can't bring claims for breach of contract, damages for breach of contract in this adjudication world. So the adjudication process itself is pretty similar to the current process. The adjudicator has to act quickly, informally, inexpensively. They have pretty broad powers to have their time deadlines extended. They can ask for more submissions. They can call a conference. The first thing they have to do is consider if they have jurisdiction. Now, one of the things they're going to do in deciding if they have jurisdiction is consider if the payment claim has been made properly. Now, you remember, payment claim has to be in writing, has to be in the approved form, has to identify the payment claim, has to identify the payment schedule. Now, these are all requirements that are similar in legislation around Australia. I'm currently involved in a bit of an argument where we have been conducting some adjudication and subsequent litigation involving the Queensland security of payment legislation. We made an adjudication application in circumstances where there were 2 payment schedules. And our adjudication application identified the payment schedule and it identified the other payment schedule as well. But the fight that is going on at the moment is whether the approved form in the Queensland jurisdiction requires a party to identify a single payment schedule. And if you identify an incorrect payment schedule, then your application is invalid. So some very interesting points of law, interesting for the lawyers that evolve out of all of this. And the matter's currently in front of the Court of Appeal. So we shall see what happens. But it's just an indication of the sorts of issues that are going to have to be agitated in WA once this new legislation comes into play. There's a lot of case law over East because the legislation over there is pretty similar. So that'll be relevant for all of us lawyers to have a look at. But once the legislation comes into effect, these sorts of things will be agitated and cause all sorts of anxiety for lawyers. So anyway, we get to the decision. The decision is made 10 days after the response, assuming that the adjudicators had their fees paid. Now, what this Act envisages is that a dissatisfied party can ask for a review of the determination. Now, it's envisaged that a dissatisfied party has to be really, really dissatisfied. And by really, really dissatisfied, I mean that the amount payable needs to be $200,000 less than the amount claimed, or that the amount payable is $200,000 different to the scheduled amount. But either party can take the matter off for a review. The review goes off to another adjudicator. It's got to be done very quickly, within 5 business days after the determination lands. But it just strikes me as being pretty unsatisfactory, because it locks up payment. Although a party going to review, if they're the paying party, they have to pay the determined amount into a trust account, so at least we know the money is safe. The party that needs the money doesn't get their hands on it whilst that review is taking place. And the review, of course, can involve further submissions. That's more lawyers' fees, and of course, it's more time. So it's not something that I personally am terribly happy about, but I can see a lot of disgruntled parties looking to possibly take advantage of that. But then otherwise, we get to the end of the process. There is a determination. There are going to be no rights of appeal, so you can't challenge factual findings, but there are going to be similar abilities to challenge determinations on the basis of what we call unfairness or judicial review. So if an adjudicator has gone outside the boundaries of what they should look at, if they've had regard to reasons that they shouldn't have had regard to, and there we can see that links back into the payment schedule and the reasons requirement. If an adjudicator's had regard to reasons that they shouldn't have and made a decision based on that, then I can see parties arguing that that's unfair because they haven't had a chance to address the adjudicator on those sorts of things. So we're going to see challenges to adjudication decisions in a similar sort of way in which we see them in the eastern states. So key takeaways. This legislation, it's going to come into effect. It's creating a new additional right to payment. It's created by statute. To take advantage of that right, you need to understand how you do it and when you do it. And if you don't comply with when and how, you won't have successfully engaged the Act. Your payment claim will be an invalid claim. I've made it very clear to you how important it is that you have a payment schedule, that you give it when you have to give it, and that you put all of your reasons in it. We're going to be really interested to see how the retention money trusts play out and how those time bar provisions are interpreted. I think there are going to be some challenges for all of us as we come to grips with this. We're possibly going to have contracts entered into under the old regime and entered into under the new regime running at the same time. So we've just got to be familiar with it. So you've got to take action to help yourselves. Please do take that action to help yourself. Don't rely on promises to pay. They don't mean anything. They're unenforceable. And as I have seen, following the insolvencies of Diploma, Cooper and Oxley, and now Pindan, it is subcontractors and it's their families who are left to suffer and carry the burden when these large entities fold. That's all from me. Thank you very much for your time. I think we've got a couple of minutes left if there are any questions. Andy.
There is one, Tom, and I'm quite proud that I can answer it, so please allow me to. I had a quick look in the bill. When putting the retention into one of these new trust accounts, the question was, does the amount put into the trust need to include GST? And the answer is yes. Retention money is defined as money inclusive of GST. And one I wanted to ask, a bit of a statement and a bit of a comment and a bit of a question, is you highlighted one of the profound changes is that under the current Construction Contracts Act, you have 90 business days to launch an adjudication from the dispute, which is typically when the invoice becomes overdue. And so practically that means right now that you can go back 90 business days to January the 11th. So an invoice due the end of January, i.e. an invoice typically for works in December, can still be adjudicated. Where that's going to change, that if under the new Act, as I understand it, where we are now in the middle of May, you would not even be able to adjudicate a February invoice. The door would have shut on that, and the 20 business day rule, the new 20 business day rule, would only allow an adjudication of a March invoice, which was due at the end of April. And so where that's going to have huge ramifications, I think, is you rightly said that there's a lot of nervousness and reluctance and even fear for people to adjudicate, companies to adjudicate, but also there's a willingness to believe promises and be strung along for any number of weeks or months. So I guess the question is, are most current adjudications you're seeing launched in that 20 to 90 day window, which is going to be shut?
Yeah, good question. Most of the adjudications we see are launched outside that 20 business day window. Of course, that payment dispute date might be earlier if the other side writes back saying on the day after they've received the payment claim, I'm not paying you anything. That's enough under the current world to crystallise the entitlement to adjudicate. In the new world, it's going to be upon the date that payment schedule is due. So we're going to have to see a shift in behaviour. People need to be making decisions quickly, and I think that's a good thing. One of the major reasons that the construction industry suffers so many insolvency events is because people don't effectively and promptly manage their cash flow. And managing cash flow includes taking action to get paid money that you are due. You have done that work. You are entitled to be paid for it. And if someone is promising that they will pay, but can't pay when it's due, then you should be immediately concerned about their ability to pay. And you should take steps immediately to ensure that you get to the front of the queue, that you get your money that you're due into your bank account. Because it might be that 6 or 7 months later, that contractor goes into insolvency. So it's important to take stock and to take action sooner. The one caveat to all of that is that you don't lose the right to claim payment for digging the trench if you've included that in your January claim. What you can do is you can include non-payment of that trench in your February claim. Then you can include it again in your March claim, and you can include it again in your April claim. You can keep recycling it, okay? But once you've adjudicated, you can't recycle things anymore. But it also means that you can only adjudicate on what's in your payment claim. So it's important to not give up on things that you might have claimed 1 month, but to keep recycling them so that you're preserving the ability to go to adjudication whenever you like, to keep re-triggering a dispute date. Thanks.
Thanks, Tom. We've had another comment from a participant. Excellent presentation and a good refresher. And I can only agree. Thanks very much, Tom, for your time in addressing this important subject. Just a reminder that if anybody has any follow-up questions, we'd be happy to connect you with Tom. But for now, thanks for being part of our Structuring for Success webinar on security of payments. Thanks to presenter Tom Jacobs from Jackson McDonald, and good afternoon to you all. Thank you. Bye-bye.
Thank you. Bye-bye.